pledge allegiance to the flag of the United States Republic, which stands one nation, under God, indivisible, with liberty and justice for all. Thank you. In the event of a fire or other emergency, please follow the exit doors that are provided in this room and throughout Town Hall. Upon exiting this room, the main exits are located to the front and the rear of the building. Do not use the elevator during an emergency event. This meeting is being recorded and streamed online to the Town of Amherst YouTube channel. Can the deputy clerk please call the roll?
Yes, just before I call the roll, can everybody please make sure your microphones are on? Thank you. Chairman Bray?
Present.
Member Schubert?
Present.
Member Phillips?
Present.
Member Parker?
Present.
Member Gergen?
Present.
Thank you. We're also joined here tonight by Zoning Enforcement Officer Daniel Latowski and Deputy Town Attorney Sam Alba. Can we get the approval of the minutes? The first item, for the minutes for Tuesday, November 19th, 2024.
So moved.
Second.
I had a motion and a second. All in favor, say aye.
Aye.
Any opposed? Passes 5-0. We're going to take number 5 out of order tonight. That is 1750 Niagara Falls Boulevard. Will the applicant please come to the podium? State your name and address in the microphone, and just make sure that it's also written on the sheet provided on the podium.
Mr. Chairman, just for the record, I have to recuse myself since our firm represents Benderson.
Thank you for taking me early. Good evening. My name is James Baglioli. I'm an attorney for Benderson Development, 570 Delaware Avenue. We'll start with the project. It's a request for 2 variances in relation to a 32 square foot sign we'd like to add at this property. If the board is familiar with this property, it's a small building we own right off the 290 on Niagara Falls Boulevard and Ridgely Road in the southeast corner. Its driveway and only access is on Ridgely. It has no access on Niagara Falls Boulevard. We own all the abutting property in this area. There's a commercial use right to the east of it. Next slide, please. Basically, we have an existing sign up on Niagara Falls Boulevard. We have 3 tenants in the building. As we develop the Costco, which is further east, and we get more traffic on this road, we're looking for a small directory sign located right here in this island. The sign will be 7 feet high and a little bit, 7 and a little by 4 feet wide for 32 square feet. Your code allows 370 square feet of signage. We're looking for 402.46. That's the 32 square foot. The setback is to the east. That's the this property line here, right here. You require 25. We're looking for 11.6. If we went to 25, the sign would be located in the drive aisle. There's actually not enough room to put it there. It's a very small sign, but not a lot of area. Next slide, please. This is the site plan that provided to you. You can see the sign is located right there. We do meet the setback off the road. We did push it into the middle of this green space. It is, as I noted, a very small sign. It'll only have the 3 tenants on the building with it. It's more we see this entire area as a large commercial shopping center for us, and this is more of a directory sign now that we're driving so much traffic here for these tenants. Next slide, please. I did submit a letter going through the 5 criteria. That letter is dated November 12th. I'm not going to read the letter to you. I'm going to highlight the 5 criteria and answer any questions. Whether there'll be an undesirable change in the character of the area, we don't believe that's the case. This is a highly commercial area. The sign is very small and consistent with the other signs in the area. I did provide pictures of those signs, and it's consistent with other variances. We got variances for next door to have additional signage. We're allowed to have 2 signs on the property because it's a corner lot. We only need the size and the setback. We cannot achieve the benefit by any other variance. The second sign is permitted, but we need the small increase in size since we're already at our maximum, and there's no way to meet the 25-foot setback. As far as whether it's substantial, I don't believe 32 square feet of addition is substantial. It's actually a 10% variance, so it's a very small variance. And the setback, this is a small sign. I don't think it's significant. It does abut commercial property to the east. It's not abutting neighbors. We're going to have a deleterious effect, and there is a fence in that area, so they're not even going to be able to see the sign. It will not have an adverse effect on the physical and environmental conditions of the neighborhood, and the hardship is self-created. We did create this hardship, but that's not determinative of the 4 criteria. there's no harm generated by this variance, and we ask that you approve it.
Thank you.
Thank you.
Does any member of the board have a question for the applicant? All right, hearing none, is any member of the audience here to speak on this item? Okay, we'll close this hearing. Would any member of the board like to make a motion on this item?
Move to approve.
Second.
Motion by member Phillips, second by member Gorgon. All in favor, say aye.
Aye.
Any opposed? Thank you, that passes.
Abstain.
4-0 with member Schubert abstaining.
Thank you very much, and
Thank
thank you again for taking me early.
Okay, we'll go to the top of the agenda, the property for 182 Lafayette Boulevard, a special use permit. Would the applicant please come to the podium?
Hello, board.
Please make sure you say your name and address into the microphone. Make sure it's written on the sheet on the podium. Make your presentation, please.
Tim Kukulka, 182 Lafayette Boulevard. I'm applying for a special use permit for a 526-foot ADU under the town ADU pilot program. This is the maximum square footage allotted for that piece of property. It's a one-bedroom apartment above the garage. Can you go to the next slide? So currently, the garage is one story. The proposed unit would go above the garage. One bedroom, a kitchenette, walk-in closet, and a living room. The bathroom is above the breezeway. Therefore, we're going to enclose the breezeway as well. Notice that the roof line is similar to the roof line and windows in both the main structure and the proposed project. Separate entrance will be on the right-hand side with the stairway up to the second floor of the garage. Yeah.
All right, thank you. Does any member of the board have a question for the applicant? All right, seeing none. Is any member of the audience here to speak on this item? Okay, we'll close the hearing on this item. Would any member of the board like to make a motion on this item?
Motion to approve.
Second.
That was a motion by member Parker, second by member Schubert. All in favor, say aye. Aye. Any opposed? That passes 5-0. Thank you. All right, I'm sorry. I think I had to do a negative deck on that, correct?
Mr. Chairman, we evaluated this for seeker, and it actually is an exempt action now for a use that is permitted. So it is an exempt action. Seeker is done.
All right, thank you. All right, the next item on tonight's agenda is 305 Mount Vernon Road. The applicant come to the microphone.
Hello, I'm Kelly Navarro, 305 Mount Vernon Road. My architect is here to speak on the project as well, but I'm here requesting a special use permit for an ADU in the rear of my property that will be attached to my garage. It is 725 square feet. That's not. He has some drawings. Those aren't my drawings. There we go. That is, okay. So here's the facing in the backyard, facing the back of the house. It would again sit and be attached to the existing garage. It's going to be 1 bedroom, 1.5 bath with a small kitchenette area. My father is 89. He's going to move in. He's currently in assisted living. I don't know if you want Dave to speak on the.
Yes, please.
Hi, my name is David Fleming. I'm the architect, and there should be a floor plan somewhere. There we go. The addition is located directly behind the existing attached garage, and it's attached. The addition for the ADU is attached to the attached garage, and so you enter the the ADU from the right side of the building, and you can see how you enter into a living space with a bedroom and bathroom in the back.
Thank you. Does any member of the board have a question for the applicant?
There's How's the driveway work with that?
The driveway is directly in front of that existing, it's a one-car attached garage, so you kind of make out the garage, the overhead door there, it's at the front wall of that garage. So that driveway runs right to the road, and then there's a little walkway around the right side. You can see that man door, you know, on the,
The access to the unit would be by the walkway?
yes. There should also be a site plan. I don't know if we showed the walkway or not, but there is a walkway there. There it is, yeah. So we show the driveway. And I think there is a walkway shown there. Very faint. There's also a fence there on the right side of the property.
Right, do we have any other questions for the applicant? Thank you. Is any member of the audience here to speak on this item? Okay, we'll close the hearing. Would anyone like to make a motion?
Move to approve.
Second.
Motion by member Schubert, second by member Phillips. All in favor, say aye.
Aye.
Any opposed? Passes 5-0. Thank you very much.
Thank you.
The next item on tonight's agenda is 64 Schiller's Road? Schiller's Road? Please state your name and address in the microphone and make sure it's written on the sheet, please.
Joanna Bauer, 64 Shoals Road, Amherst.
And James Blankenberg.
We wanted to put up a pole barn on our property. Not for business purposes, just for storage. I'd like to park in my garage. Lawnmower gets in the way. What else to say?
All right. Do you have anything else?
As far as it, our house, the square footage for the area, we need the variance to be able to put up a barn.
Thank you. Does any member of the board have a question for the applicants?
How are you going to access it from the main roadway?
There's a driveway that runs alongside of the house all the way to the back of the property. It's
Okay.
already there.
Have you spoken to any of your neighbors about the construction?
Yeah, they all have barns. I mean,
Almost everyone on the street.
yeah. And we won't really be driving back there. It's more or less just for storage and stuff.
Lawnmowers.
Yeah, we won't be parking back there or anything like that.
Any more questions for the applicant? Any member of the audience here to speak on this item? Okay, we'll close the hearing. Would anyone like to make a motion?
Motion to approve.
I have a motion by member Gergens. Do I hear a second?
Second.
Second by member Phillips. Let's just go over the criteria really quickly. The first is character of the neighborhood. The applicant expressed that there would be no real change of the character of the neighborhood since the neighbors have a similar structure on their property. The second is, were there other alternatives? That is not really feasible for the applicants. Third is if it was substantial nature. No, it is not. It is not a severe variance that they are requesting. The fourth is a physical or environmental condition. If it impacts the physical or environmental conditions of the neighborhood district. No, it does not. It'll be similar to, it'll be a similar change than what currently exists. And if it is self-created, yes, this is self-created. And even though it is self-created, that is not a reason just to deny the application, deny the request. All in favor of this request, say aye.
Aye.
Any opposed? Thank you. The next item on tonight's agenda, it is 2920 Niagara Falls Boulevard. The applicant, please come to the podium. Please state your name and address to the microphone.
My name is Paul Wilcox. The address is 2920 Niagara Falls Boulevard. We would like to replace an old worn sign with a new eye-pleasing pole sign. The sign is for Buffalo Feline Hospital. The new sign should only increase property value because of its appearance. It'll be harmonious in nature to the signs in the same area to size and appearance. Because of this, it'll also be non-distracting to drivers. There are two businesses. The other business with the ground sign is Bella Moda Salon. We do not think it is fair to Bella Moda Salon to remove their sign and add a sign onto the proposed sign at Buffalo Feline Hospital. Their sign would be smaller, less visible, and not located directly in front of their business. Where the Bella Moda Salon is currently located is very visible and familiar with their clients. A lot of clients are elderly and use that sign to locate the business. Also, for new clients, finding the business would be harder. In seeking a variance, we think neither an undesirable change in the character of the neighborhood nor a detriment to nearby properties will be caused. The request variance would increase curb appeal both for Buffalo Feline Hospital and the town of Amherst, help attract business to Buffalo Feline Hospital, keep good signage and therefore good business at Bella Moda Salon. For these reasons, we think the variance would be substantial in a positive way to both businesses and Amherst itself. It also goes in, we've been making some improvements to the building, and we're going to have continued improvements with the building, so it goes hand in hand with that as well.
Thank you. Does any member of the board have a question for the applicant?
I actually have a, maybe, Dan, you can help me with this.
He just stepped out.
Oh, okay. It says here the petitioner's sign will be 190 feet from an existing ground sign. What existing ground sign are we talking about?
Bella Moda Salon.
Oh, the salon.
The salon, yes.
Okay. And the other question I have is, would there be any, you're taking down the Boulevard Animal Hospital sign, according to this. That sign's coming down.
Yes, the existing sign.
And would it
yeah.
be possible to put the address 2920 on the new sign? That's something we've been requesting in the past. Could be further down in the pole just to, so people can see the address.
I don't see that as being a problem, no.
All I've got. Thank you.
All right. Is anyone, any more questions for the applicant? Is any member of the audience here to speak on this item? Okay, we'll close the item. Would any member like to make a motion on this?
I'll move it with the stipulation that the address is placed on the sign also.
We have a motion for it to be approved with the stipulation that it has the address on the sign. Do I hear a second on that?
I'll second that.
I have a motion by member Schubert, second by members Gergen. All in favor, say aye. Aye. Any opposed? That passes 5-0. Thank you very much.
Thank you.
On the next item of the agenda, 3999 Maple Road.
So I'm the applicant, Julia Chen. My address is 20600 Chagrin Boulevard, Suite 500 in Shaker Heights, Ohio, 44122. But I am the civil on the project, civil engineer, so I'm actually going to have John speak, who knows a lot more about the building.
Good evening, everyone. My name is John Iskey. I'm the Director of Real Estate with Brewtopia. Brewtopia is the franchise group that's very excited to bring 7 Brew to Western New York. Also, Amherst would be our first open stand in Western New York, so we're excited about that. We are here in front of you tonight to discuss and request variance relief for 2 things that fall in line with each other: the 2-story functional building and the 35-foot minimum building height. Part of the franchise program with 7 Brew is a prefab building. So it's 510 square feet, steel structure. We use Nichiha clad panels on the outside to give the brick appearance. and simply due to the fact that it is prefab, it's manufactured in Missouri, and then it'll come out on a truck and be delivered to the site. Based on that, we had limited options to try and expand the footprint. Worked with Dab on some other issues successfully. So here tonight in front of you for the 2-story functional building and the minimum building height.
All right, thank you. Does any member of the board have a question for the applicant? All right, seeing none, is any member of the audience here to speak on this item? Okay, I'll close the hearing on this item then. Would any member of the board like to make a motion?
I'll move to approve.
The motion by member Schubert, is there a second?
Second.
Second by member Skirgan, all in favor say aye. Aye.
Aye.
Any opposed? That passes 5-0, thank you.
Appreciate your time. Thank you.
Now, on the seventh item of tonight's agenda is 2577 Millersport Highway.
Good evening. I'm Jeff Palumbo from the law firm of Block Longo, representing the petitioner Bevilacqua Development. With respect to the 2 variances before you this evening, the property, as you're all very familiar, is the current Nina's Custard stand that's been there for a number of years on Millersport Highway. You can go to the next slide, please. The overview of the site is, as you see here, the property is measuring approximately 1 acre in size. And the key to this is that it's own neighborhood business and not general business. It's currently developed with, as I said, the 1-story concrete building for Nina's Custard, and it's adjacent to a number of other similar type uses, which is Burger King, a bank and Rite Aid nearby. There are residential properties to the east, and again, on a prime location on Millersport Highway. Next. So what are we actually doing? What we would like to do here is to introduce to this site a national coffee company that requires, as part of their development, a drive-through. No drive-through, no coffee shop here. The reason why we're here is the NB zoning district does not allow drive-throughs. So we've asked for a variance for that. The second variance that we have requested is with respect to the location of the speaker itself, which in the district that we're in requires a 100-foot setback, and we are at approximately 20 to 25 feet, 20 feet. So those are the 2 variances, and I'll go into some of the discussion. We've given you a detailed application. I know you've all looked at it, so I'll try not to repeat everything in the application, but there are things that are important, so we can go to the next slide, please. This is just, you can go through these. This is the existing building that will certainly be modified. There will be landscaping that will be added once we resolve this issue, if we resolve this issue. So the proposed development that we see, it will be a quick service coffee cafe with drive-through service. And all the statistics show us that at least 50% and as much as 70% of the coffee being sold at these locations now are through drive-throughs. That's why it's so important. Without the drive-through, there, as I have indicated, there will be no coffee shop at this location. We think that that's an improvement, however, because of the fact that we will then be modifying the site plan, adding new landscaping, improving the traffic circulation, updating the lighting and all the site amenities, bringing it back into a more formal site plan. It's a little worn out as it is now. Next. So the variances that we're looking for are area variances for the drive-through. An area rather than a use variance, and I thought this was important because we've had this discussion in the past. Based on the higher standard for a use variance, there's case law that indicates that this type of use is a area variance. The request is an area variance, given the fact that the use is a coffee shop. So the mobile case demonstrated that very clearly, and I think we're all in agreement with that at this point. There's also the area variance for the speaker location, which I've indicated is required to be 100 feet from the residential properties. Next. So the benefit versus the detriment, you're all very familiar with that. You discuss it at every meeting. The benefit to the applicant versus the detriment to the health, safety, and welfare of the neighborhood should the variance be granted. And the benefit that we have set forth to you is what I've already said, that the coffee shop will be there. If there's a drive-through, that's the benefit to the applicant, having the drive-through, having the coffee shop. We don't think that there's any detriment, and I say that because of the fact there is substantial landscaping buffer existing on the site now. We will be adding to that buffer with additional landscaping. So if there's any questions with respect to the location of the speaker, we can handle those issues. And again, we all know that the Burger King, I think many of us anyway, remember the Burger King back then that was blasting through the speaker when it first opened. Those days are gone. The speakers are now digital. They're automatically adjusted for volume. It's a much different situation than it used to be in anything that's been built recently. Next. Character of the neighborhood. We'll show you some detailed plans later of the area itself, but we're certainly not going to impact the character of the neighborhood by introducing a drive-through. The use is essentially the same as what it was before, a restaurant use. And as they've indicated, all of the other things that you see up there are located within basically spitting distance of this site. Next. So here's what I'm referring to. Up on top is the proposed coffee restaurant. Each star that you see on the plan is a drive-through. The Rite Aid adjacent to us, the Burger King, and the Cornerstone Federal Credit Union. Next. Are there any alternative methods? No, we have gone through the exhaustive procedure of trying to find a way to minimize the variance request with respect to the speaker, and this is what we came up with. There are really no alternative methods in achieving the benefit that the applicant is seeking. The distance between the speaker itself and the drive-through needs to be 7 spaces, and we have done that. And then there are an additional 5 stacking spaces beyond the speaker itself. So we have 12 stacking spaces on site and plenty of extra room if that's necessary, which we don't believe it will be, but it's there if necessary, which is why we talk about efficient traffic circulation. Next. Is the request substantial? And again, you've heard this from us many times. New York says it's not strictly a mathematical formula. It depends on the impacts that result from the variances. And because there are districts in the immediate vicinity that allow similar type drive-throughs, we don't think that this is a substantial request. And again, because of the mitigation that we can import onto the site with respect to the speaker system and the buffer, the existing buffer, we don't think there will be any negative impact, and therefore the request is not substantial. Next. There will be site improvements, so if there are any environmental impacts as a result of this, we think they will be positive and not negative. The existing vegetation in the rear of the site to the east of the site is substantial. Also on the south side, the downward facing LED lighting with cutoffs, the lighting will not be an issue. Limited hours of operation and physical design elements that we've talked about for the stacking and the speakers themselves. And the self-created hardship is one factor to determine and not the sole factor to determine with respect to area variances. So we would ask the board to take into consideration what we believe to be the benefit exceeding the detriment in this case and granting the 2 variances. There may be some additional pictures. I'm not sure if we added them or not. No, that's it.
All right, thank you. Does any member of the board have a question for the applicant?
One question. With respect to the Burger King, Rite Aid, and the credit union, how far are the speakers away from the residential district boundaries?
That's a good question. Let's take a look. I would say that speaker is probably 100 feet, 150 feet. The speaker for Rite Aid I'm talking about, the speaker for Burger King is much closer. It's probably the same distance as us, maybe slightly more. And then the Federal Credit Union is probably also 100 feet or so. I'm not sure that they needed variances or not. If that's the question, I'm not 100% sure.
Not to put you on the spot, but do you know if Burger King received a variance?
I do not know.
Okay. So, yeah.
Any other questions?
I have a question. If, Mr. Palumbo, if you were to bring the speaker back 100 feet, how many stacking spaces would you be left with? Right now you said you need seven.
Can we go back to the site plan, which is way in the beginning? So if we move that speaker 100 feet, it really destroys the whole outlet. We take it around the back, and it'll be at least 10 to 12 spaces away from the reader board, and it just doesn't work that way. It's just, that they've got, as you know, this is all down to a science on how many spaces should be between the speaker board and the takeout area itself. So to move it 100 feet would really not work for us. And those are the things that we were looking at when we came up with original plans, and we felt this one was the best, given the fact that we can buffer it so substantially.
Thank you. Any more questions for the applicant? Okay.
And you said, one other question, you said drive-through, that's a requirement for this company to consider this
Yeah,
location.
no drive-through, no project. It's part and parcel of this project.
Right. We're going to hear a presentation from zoning enforcement officer Dan Ulatowski, but before I have him speak, I'd like any member of the audience who's here to speak on this item, could you please come to the podium? Please make sure your name is written on the sheet there, as well as say it into the microphone.
Okay. My name is Melissa Semide Finley. I'm representing Robert Semide, Kathleen Semide, and Anthony Palumbo, all who live in Collins Court, the area neighborhood immediately adjacent to the project. So I haven't reviewed the case law that was referenced, but we would like to object to the idea that a use variance is not required here. The code very specifically references that restaurants without drive-throughs are permitted uses. It doesn't just say restaurants. It very specifically mentions without drive-throughs. So the intent of the code is clear. So our belief is that a use variance really should be needed here. And then as far as the area variance, I can say that the neighbors not only are concerned about the speaker, but also just about the traffic that's going to be basically in their backyard. It's not been confirmed what coffee shop's going to be there, but I think most of us are of the understanding it will likely be a Starbucks. The traffic associated with the Starbucks and the drive-throughs are pretty much consistent traffic throughout the day, long lines of cars throughout the day. So you're going to hear cars idling. You're going to have exhaust from those cars basically right in their backyard. So it does change the character of the neighborhood and would adversely affect their enjoyment of their property. And also lower property values. Most people don't want to drive through and 10,000 cars in their backyard. So we believe under the first factor of the area variance, if there will be an undesirable change in the neighborhood, there absolutely will be. In regards to whether the benefit sought by the applicant can be achieved by a different method, I understand that the applicant believes that a coffee shop can't thrive without a drive-through, but there are plenty of successful coffee shops in the Amherst area that do not have a drive-through, and they're businesses that have been around for quite a while. So I don't know that we necessarily agree with that assertion. And then in terms of whether the requested area variance is substantial, the variance that's being requested is only 1/5 of the allowable setback. So the code contemplated that 100 feet should be the setback for a drive-through from a residential property line, and this is only 1/5 of that, and that is from our perspective, a very extreme and substantial variance. We're not talking, 80 feet, we're talking 20 feet when it should be 100 feet. So that's a pretty extreme variance. And then whether the proposed variance will have an adverse impact on the physical or environmental conditions of the neighborhood, we do anticipate that this will increase traffic. There will be constant car exhaust all day, which from an environmental perspective, again, of the immediately adjacent neighbors, is just not an ideal condition and will adversely impact them. And as was referenced, the fifth factor of the area variance isn't really relevant here because that's not dispositive of whether you should grant it. But that is why the neighbors in Collins Court do formally object to this project.
Thank you. Does any member of the board have a question for this individual?
Is it just one home on Collins Court that these people live in?
homes.
Okay, and I'm assuming they're the two closest to the corner of this
So
property?
the one that's actually right there.
Actually, can you go back to this one?
So I can say Mr. Palumbo has the residence that's the closest. And then Mr. and Mrs. Themade have the one that's right next to his.
So that one
Yes.
belongs to who?
That is to Mr. Palumbo.
Okay.
And then Mr. and Mrs. Themade are right next door to Mr. Palumbo. And then the neighbor to the left also objects. Unfortunately, she could not be here today, but all of them share these concerns.
Thank you.
And then, I did want to mention one other thing. We acknowledge that there is already a drive-through at Rite Aid and Burger King and also the bank, but the nature of those businesses is very different. So again, we're under the assumption, can't confirm that this is going to be a Starbucks restaurant. There will be constant huge lines of cars there. If you go to the Rite Aid, and we all live near this neighborhood, there's maybe one car there every few minutes, maybe two at the most. The same with Burger King. Often that drive-through is empty. Maybe there's one or two cars. You're not talking about a parade of cars around the building 24/7. So I think the nature of those drive-throughs is very different than a Starbucks.
Thank you.
Would the nearby homeowners still object if it was, 80, 90, 95 feet as opposed to 20 feet?
I think that they would be more amenable, and I don't want to speak specifically for you, but if the distance was expanded. But 20 feet, I mean, it's really right in their backyard.
Thank you. Is any member else here to speak on this item? Come to the microphone, Mr. Zugala. Name and address.
Councilman Mike Zucala, Amherst Town Board member. I live at 150 Stewie, which is not far from this. It went so fast, I'm sorry. My only question is, what's the name of the vendor again that's setting this property up? It was on one of the early slides. That's all I ask.
Thank you.
Actually, if you look at the diagram and you look
Could you
at,
please do your name and
Tony Palumbo is my name. I live probably the closest, meaning if you look at Nina's and you look at, I'm the right over, there's Nina's, there's a fence, and then there's me. Okay? So, obviously it's a restaurant that's been there. I've been there for 14 years. Okay? But it's been without a drive-through. So it's important to know where the drive-through is going to be. I'm a little confused exactly. In other words, from the fence, which is the red line, separating the property, right? That is the fence. So from that fence, where exactly how many feet from the fence is the drive-through going to be? I'm a little confused there. 20 or 100 or 80?
we'll let the applicant answer that question. You want to come up?
Got to be a couple hundred feet.
Let's go to the site plan again. This one. So let's just talk about the, yeah, I'm gonna do that. I'm gonna do that. So first of all, this is the speaker, okay? So when we talk about the drive-through, here's the lane, obviously. This is the window over here. So if this were moved 100 feet away, it does nothing for the house over here. In fact, it might bring it closer. If that's the house that you've identified that you live in, moving this 100 feet brings this closer to your house rather than farther away. So when we talk about the distance between here and here, this whole thing is 350 feet. It's about 175 to here, so it's about 125 feet to the proposed driving lane, approximately. All those numbers are approximate, but again, I think the critical thing is, move this over, it's closer, not farther.
Let me ask you this, if I may. Is where the drive-through actual lanes at the back of the property, the back of Nina's property, is that going to be pretty much consistent with the back of where the back parking lot ends now, or are you extending past that?
It extends slightly past that, but it can't go much farther because of the original restriction that was placed on the property. So it's essentially the same place.
Okay.
Thank you.
Does that answer your question, Tony?
Well, just explain to me now, so when a customer comes in and goes through the drive-thru, where are they coming from? This is Miller's Court.
Yep, they'll come in here.
Okay.
They'll get in this line here. They'll go around here to the speaker. They'll order there, right?
Okay.
They'll go through here and then out the same way.
So
But they could go
roughly
this way too. but-
So from the fence, it's about 120 feet.
Yeah, it's about 120 feet, and that's all buffered in there. 120. From here to here, it's about 120 feet.
And then you're talking about
From,
the other fence, where closer to here.
Yeah, okay. So,
answer the question?
yes, Mr. Ulatowski,
And I
would you
don't
like
think
to?
Tony and I are related.
So for the petitioner's benefit, I wrote a memorandum to our zoning board and asked that they consider adjourning this matter. And the reason for that request is the planning department has concerns for setting legal precedent. As you know, there's case law. Once a zoning board makes a decision, they should be consistent with that decision throughout. So we are asking the zoning board in this matter to pause until the February meeting because since this application was filed, I was of the opinion that the case law that Mr. Du Bois, the second counsel to Mr. Palumbo, was accurate, that this should be treated as an area variance, and it still may be, should still be treated as an area variance. However, in looking back at the actual zoning ordinance, I went back to the first zoning ordinance adopted by the town, which was roughly 1930. No reference to a drive-through, obviously, in 1930. The second zoning ordinance adopted roughly 1960 had distinct language pertaining to restaurants without drive-through service. In the NB district at the time was the B2 district. This parcel of land at one point in time was zoned SA. It sought a rezoning to B3, which at the time was our general business district. And if you look at the 1960 ordinance up to the then subsequent ordinance, I call it the third ordinance, we still had a B3 district, a general business district, which made a distinction between the two types of restaurants. In the NB district, B2, it specifically said a restaurant without drive-through or without outside dining. The less restrictive district, the B3 district, the general business district, allowed for curbside pickup restaurants of any variety, which then subsequently was further amended to say that a restaurant of any variety, including those restaurants with curbside pickup, however, such project shall be approved by the town board with a recommendation from the Traffic Safety Board. So that was in 1965. So what I've learned is there was a history of making a distinction in the land use. Again, the B2 district, it was a neighborhood business district. It was meant to be neighborhood-based without drive-throughs. It specifically said a restaurant without a drive-through and without outside dining. You then look to the next least restrictive district, the B3 district. It says a restaurant of any variety. And then if we jump to the third zoning law adopted in 1976, which is essentially today's law, the NB district or neighborhood business district still remains. And it carried with it that same language. It said in the NB district, a restaurant without drive-through and without outside dining. You went to the next least restrictive district. It says the general business district, a restaurant without a drive-through and with outside dining. And then it brings in one more use in the same use table, and it says a restaurant with outside dining and with a drive-through. So consistently through the creation and amendment of the zoning law, it was always defined as distinct uses. I might, tend to agree with the petitioner that maybe it should be treated as an area variance, but I'm not going to speculate on that. I'll leave that to our law department, but we're asking for a pause. We recognize that precedent was already created by this board in 1990, 91 when Nina's Custard was first constructed. The petitioner at the time, I think it was the past owner, sought a variance to allow outside dining. It was approved. It allowed for this Nina's to be constructed in an NB district with outside dining. So precedent was created by this zoning board. The Burger King, it was there in the 1970s. It was there under a B3 district, a general business district, which did allow for drive-throughs as a permitted use. In 1976, when the town went through a rezone of the entire township, they downzoned this whole area from B3 to B2, or the NB district. So there was an intent to further regulate more intensive uses. Again, this board many years ago set precedent by allowing outside dining in the NB district. We have a non-conforming restaurant, the Burger King. It's in the NB district, but has a non-conforming with respect to not only the distance of the drive-through, but even the use. The banks are allowed to have drive-throughs in the NB district. They're viewed as not intensive, as well as drugstores. So consistently, the town has said the NB districts should not be intensive. I'm asking this board to kindly adjourn it. Maybe the two parties can come to some conclusion, or maybe there can be some recognition of the context. I'm of the opinion maybe they can meet the 100-foot setback. Unfortunately, the way it's measured from the order board. The order board could be pushed maybe 100 feet away, but then the statute says you need stacking. And the statute says you need 6 stacking spaces from the order board to the window. So wherever the order board is, and let's say the order board is right there where the height pendulum is, or the sign is. Let's say you put the order board there, and let's say it's 100 feet away. You would then need 6 queues behind it. If you did that, those parking spaces adjacent to those queues would no longer be available parking, because you can't conflict with that. So after your order board, you then need 4 queues from the order board to the window minimally. But if they have the necessity of a drive-through, maybe they can reconfigure this to make it close to 100 feet away, still lose some spacing to provide the necessary queues, or maybe they seek relief for the queues after the order board, so they don't lose parking. I don't know if we have the survey in here, but this is not representative of what's actually constructed. There is a lot of parking, and again, the zoning board also created precedent. And after this was constructed, the zoning board, as a condition of the outside dining, said the area shall remain not further developed. They put a condition on allowing that outside dining. The petitioner at the time subsequently went back to the zoning board, said, could you kindly relieve us of that condition? We need more parking. So they built the parking within 10 feet of the neighboring residential uses, with the condition there be an 8-foot high fence. So if we look at what was constructed, the petitioner in this case is suggesting they will take away that parking lot or a portion of it and keep it green. So all I'm suggesting is maybe we pause. Maybe the two parties or opposing parties can come to some form of an agreement with reasonable conditions that could be carried throughout. Our concern is setting precedent against, precedent has already been set twice by the Zoning Board of Appeals. Once the relief is granted, if there's not reasonable conditions, doesn't necessarily have to be a Starbucks that could go here. Could be a Mighty Taco. Could be something, they haven't represented whether or not they'll adhere to the other conditions in the drive-through that says that if it's closer than 250 feet to a residential district, they're limited to the hours of, I believe, 6 a.m. to 10 p.m. So I think there's an opportunity for maybe an agreement for all concerned. This board may not set dangerous precedent. There could be a rational argument for why they're granting the necessary relief if no harm is provided. So that's the best explanation I can provide. And I'll be happy to give.
Mr. Palumbo a chance to respond to that before.
No, yeah, no, I that was fine, Dan. I appreciate that. We have no problem. If we can come up with a better plan than what's in front of you, we certainly have no objection to that. So I will be happy to give my phone number to whoever would like it. If they'd like to meet, we're certainly willing to do that. Bring Mr. Bevilacqua as well, and we'll see if we can work something out.
All right, well, that sounds just great. So we'll adjourn this item for tonight. We'll leave the hearing open, and we'll see you next month.
Thank you.
We need a motion.
We need a motion to
I'll
adjourn.
make that motion.
Motion by member Schubert to adjourn. Do I hear a second?
Second.
Second by Gergens. All in favor, say aye. Aye. All right, that item is adjourned. The next meeting. The last item on tonight's agenda, it is 4795 Sheridan, my favorite item.
Yes, good evening, Chairman and members of the Zoning Board. Sean Hopkins of the law firm of Hopkins, Georgie McCarthy, on behalf of the applicant RAS Development 1 LLC. Also with me is Rob Savarino, the owner of that entity. I do want to note before I begin, there is some additional information that's updated since the ZBA meeting in November. However, two things. We're not asking the ZBA to issue a decision this evening because the 30-day lead agency response period expires on Thursday, the 16th. And second of all, we are asking for the public hearing to remain open. So in the event that there is additional information as a result of any further comments from those involved agencies, that all parties involved have the opportunity to address that. So with that being said, if we could go to the next slide. I'm going to walk through this part very quickly because you've seen it again and again. The site, of course, is located at 4795 Sheridan Drive, 2.06 acres in size. It's properly zoned MFR 5, and there is one existing curb cut from this house associated with from the site onto Sheridan Drive. It is important to note that Sheridan Drive is a New York State highway. Next slide. It's a copy of the zoning map. We can see the parcel right here. Again, it is zoned MFR 5. It's also important to note that the primary opposition to this site, the parcel, of course, directly to the west, their parcel shares that same MFR 5 zoning classification. Next slide. And so why is that? So I did some research over the weekend, and if we go back to May 2nd of 2016, at that point, there was a project that was contemplated that considered both this site and, again, the adjacent site to the west at 4785 Sheridan Drive. It's important to note that Mr. Savarino was not involved at that time. But at that time, the town board, via unanimous vote in resolution 2016-269, rezoned both of these parcels to MFR 5. The town board also did issue a negative declaration pursuant to the State Environmental Quality Review Act. So that all occurred then. Then second of all, there is an Article 78 proceeding that's pending now. Petitioners have not sought an injunction. The return date for that Article 78 proceeding which challenges your approval of previously granted variances, as well as the environmental review pursuant to seeker. That is pending, and again, hopefully will prevail in that litigation. Time will tell. Next slide. Project timeline, I'm not going to walk through this, but we started, of course, with a hearing on May 14th of last year, and we're now at our 6th public hearing. This has nothing to do with the Zoning Board of Appeals. It's not your fault. There have been some modifications, and ultimately, after you originally approved the variances several months ago, we identified the need for an additional variance, primarily because of a zoning condition, again, that was imposed by the town board in 2016. Next slide. And that's a summary of the Article 78 proceeding. Again, the town attorney's office, Mr. Alba's here this evening, and I are handling that on behalf of the applicant, the town of Amherst, and petitioner's counsels here as well. And again, that is returnable on February 13th. Speaking from my perspective, we're quite confident that the Zoning Board of Appeals did its due diligence, and that its decision was not arbitrary and capricious, either when it comes to the seeker determination or the variances. But ultimately, that will be up to a Supreme Court judge. Next slide. Project modifications. It didn't. The August 13th layout, I'm sorry, it's a little bit disjointed in terms of orientation. Those were the variances we needed. Again, we had a building out along Sheridan Drive, which you can see, a short side along Sheridan Drive, and then we had the back building. What we've done now is we've simply moved everything back from Sheridan Drive. So you can see we're now at a 115-foot setback versus what we originally were, which was 26 feet. And we've moved the whole project basically further to the south. It's important to note that building number 2, the rear setback is now 38 feet compared to 35 feet from the previous plan. And we've also, the building side yard setback is now 39.41 compared to 48.51. And keep in mind, the property directly to the east is a National Grid right-of-way. So variances on that side of the property to the east, I think it's very debatable at best that you could argue that's going to have a detriment on community character. It's also important to note that we thanked Mr. Ulatowski several months ago. He reached out to National Grid. That allowed us to have some conversations, and they have confirmed they'll allow us to put plantings in that right-of-way, which will obviously provide screening primarily for the benefit of the condo association on the other side of the right-of-way, as well as the Park Country Club. But this project will have no impact on either of those uses. Next slide. As you'll also recall, we made some serious modifications to the elevations based on input we received from the Zoning Board of Appeals early last summer. This remains the elevation that we're proposing. It cost approximately $250,000 more than our baseline elevation. We do agree it's much, much nicer than what we originally presented. And you did impose this as a condition, and we're still comfortable with that condition. Next slide. And that just shows, again, the modifications that we've made. Again, vertical and horizontal relief. We've added some stone, enhanced the building materials. We have that covered building entrance, which is certainly good during inclement weather. And as I've already said, that totals about $250,000. Next slide. In terms of the variances we're asking for, the only variance that we're here for this evening is variance number one, which you previously granted in blue. Because of the modifications we've made, and we discussed this during your November meeting, we do not need that variance anymore. So if we get the variance we're seeking from this board, that will be withdrawn. We've already confirmed that for the record. The only variance we're asking for, and that we've been asking for since October 16th, is the side yard setback of the east building of Building 1. Again, that's the building with the shorter side facing Sheridan, and the setback of that building is 48.87 feet is required based on the mean building height of 32.58 feet. And again, I'm sorry, this is the back building. And what we're proposing is 39.41 feet as measured from the National Grid right-of-way, not from any adjoining single-family home. Next slide. That's a copy of the resolution, again, that you adopted on September 17th. And again, I want to confirm two things. We now will be able to withdraw variance number 1, front yard setback, and number 2, the conditions that you imposed, which I believe are on the next slide. Next slide. Those are the conditions you imposed. Again, I've talked about the architecture, condition number 1, but also you did impose condition number 2, which we submitted in writing and asked you to impose, which is to install a 6-foot tall privacy fence and landscaping along the western edge of the portion of the project site. Again, that site is zoned MFR5. It's now been zoned for MFR5 for nearly 9 years, but it is a single-family home. So we recognize the fact that we should provide some screening, a 6-foot tall privacy fence, and extensive landscaping. And Mr. Savarino has deliberately designed the site to push as much of it to the east edge of the site versus the western edge of the site. Next slide. And you can see the variance that we can withdraw. Again, front yard setback from Sheridan Drive. And in purple there shows the modification. Again, building 1, which is the back building, is simply moving closer to the eastern property line. Next slide. In terms of the balancing test and the 5 criteria, we've been through this again and again. Clear as day, there are substantial benefits to the applicant, and we don't believe in this instance there are any resulting detriments to the health, safety, and welfare of the neighborhood. We think we've actually designed a project that's much better than an as-of-right layout. As you'll recall, the density remains unchanged. We're at 24 units. We're allowed 24 units under the code. So it's just really how does it lay out? What does it look like? What is the landscaping, et cetera, et cetera. And we think we've done a good job in terms of maximizing the benefits to the applicant, again, while not resulting in any detriments as a result of the current site layout and the conditions we've agreed to previously. Next slide. I do want to talk on area variance criteria number 1. Again, we don't believe this project will result in undesirable change to the character of the neighborhood or detriment to nearby properties. Area variance number 2 is whether, of course, there's some other feasible method that could result in basically what we're asking for, the benefits, without the need for a variance. And the answer to that question is no. We need this to be pushed closer to the National Grid site. That's what we've done. We also have an easement in place that predates Mr. Savarino that requires buildings to be 10 feet back from the easement that's on our site. We're complying with that condition. Otherwise, we push the buildings even closer to the eastern property line. Whether or not the requested area variance is substantial, and the key inquiry there is whether any harm will result, and we think clear as day the answer is no. Whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood. You've explored all of those impacts, traffic, community character, et cetera, et cetera. Those are all documented very well in the negative declaration you issued on September 17th. We have submitted an amended Part 1 of the full AF with the pending variance application. It's important to note that obviously Ellicott Creek is the southern boundary of this site. No impacts whatsoever on Ellicott Creek or the associated floodway with that particular navigable waterway. And then we're only proposing, based on the updated layout, 1/10 of an acre impact to the regulated 100-year floodplain. Mr. Savarino is well familiar with the town's floodplain ordinance and the requirements for that, and of course, we will comply. And then finally, whether or not the alleged difficulty was self-created, which cannot be the sole basis for your decision-making, but we do acknowledge, because we have knowledge of the zoning code itself, that this could be viewed as being self-created. Next slide. I just want to focus now on the seeker review, because basically what we became aware of is not pursuant to the actual regulations pursuant to seeker promulgated by the New York State Department of Environmental Conservation, but pursuant to a local law that was adopted many, many years ago by the town board in 1982, specifically Chapter 104, Section 104.3. There's a requirement that any project, any proposed action that's within 100 feet of a flowing water course, any site, requires it to be treated as a Type 1 action, which then simultaneously triggers the need for a coordinated environmental review. The planning department, as I indicated, did issue a lead agency solicitation letter and provided documentation to the involved agencies on December 16th. That 30-day response period expires on January 16th, and 2 things will happen. We either get responses from those agencies, which I believe we've received a response from the DEC, or at that time they've waived their ability to comment, meaning many of these agencies probably are fine with the ZBA acting as the lead agency because their jurisdiction is much smaller and much more minor compared to this board's. Next slide. This is also subject to a waterfront consistency determination because we are in the waterfront revitalization plan that was previously adopted by the town board. Again, I want to emphasize the fact only 1/10 of an acre impact to the 100-year floodplain, no impacts to the creek itself or the regulated floodway. It's also important to note that if and when you grant the additional requested variance, and if and when we prevail in the existing Article 78 proceeding, this project still will require site plan approval from the planning board. A complete, distinct, and separate review process, and they will look at the very specifics in terms of lighting, landscaping, stormwater management, requires the review of fully engineered plans by numerous town departments and committees. Next slide. That's just a version of that site plan showing, again, the current site plan where we've moved the whole project back from Sheridan Drive. And the sole purpose of this particular plan is to illustrate that very minor impact to the regulated 100-year floodplain. Next slide. We also have previously provided a traffic analysis that was done based on a request, I believe, from a nearby property owner. It confirmed clear as day this project will not result in any potentially significant adverse traffic impacts. As you'll also recall, despite evidence that indicated otherwise, there was a concern raised by nearby property owners about sight lines of the building closer to Sheridan Drive. That all goes away. We've now moved that building again, so it's 115 feet back from the center line of Sheridan Drive. So it's really difficult for anyone to claim that there's concerns about sight distance. Next slide. The other update that we have is because we're now impacting a little bit more of the project site, we had to go back and revisit the cultural and archaeological survey that was originally done by Pat Powers, Powers Archaeology. We did submit an updated report dated August 8th of 2024 to look at that additional area. They basically, oh, this is the original. We did that, and then on August 12th of 2024, they issued what's known as a no impact determination, confirming that, in their opinion, this project will not have any impacts on cultural or historic resources. We also did receive a letter, oops, I thought I turned my phone off, from SHPO confirming that from their perspective, this project will not result in any impact on historic resources, namely the Country Club of Buffalo, or not Country, Park Country Club, located to the east of the project site. Next slide. That's copies of the correspondence, again, that was issued in response to that original cultural resource survey. There were two separate letters, one addressing cultural resources and one addressing historic resources, and this is the second of those two letters. Next slide. And now is where I wanted to go previously. We were required to update that report. We did so on November 15th based on the additional impact, limited to only 0.16 acres. We complied with the methodology required by SHPO with 12 additional on-site shovel tests. That resulted in no additional evidence of impacts on cultural historic resources, and in their opinion, no additional work was warranted. Again, they being experts, Powers Archaeology, in terms of archaeological and cultural resources. Next slide. So based on that additional updated report, we did once again receive no impact determination letters from SHPO. The first of those two letters dated November 18th of 2024 to Scott Marshall, again confirming in their opinion and their expertise, this project will not result in any potentially adverse impacts to cultural archaeological resources. Next slide. And then a second letter dated November 19th, once again to Scott Marshall of the Planning Department, confirming that in their opinion, this project will not result in any adverse impacts to the Park Country Club of Buffalo, which is eligible for state and national listing. And then it's important to note that basically they did confirm that that's based on us providing a vegetated buffer along the eastern property line, including the National Grid property, which we've already indicated we will be doing. Next slide. That shows that buffer, shows the easement line, and shows the National Grid right-of-way. And again, that's based on input that Mr. Savarino received out from National Grid after originally Mr. Ulatowski reached out to them. Next slide. That's showing the proximity to Park Country Club. As I indicated, SHPO has confirmed there'll be no adverse impacts. And as you can see, it's a considerable distance, 425 feet from the property line to the edge of that right-of-way. Next slide. We've also previously provided a stormwater letter confirming that, yes, indeed, our stormwater management system will comply with the DEC's stringent standards for both stormwater quality and stormwater quantity, including the need to handle on-site a 100-year storm event. Clearly demonstrates that in the professional opinion of our engineer, Patrick Sheedy of Carmina Wood Design, that this project will not result in any potentially adverse drainage impacts. Next slide. So with all that being said, I want to confirm three things. No adverse impacts on Ellicott Creek. In our opinion, in the previous opinion of the ZBA, based on the previous layout, the project will not result in any potentially significant adverse environmental impacts. You'll need to make an updated seeker determination when you vote. And then in our opinion, and we think we provided more than ample evidence, that the granting of the requested area variance is justified based on the balancing test and the 5 criteria. If there's any questions relative to the extensive documentation that this board has received over the course of the past 8 months, either Mr. Savarino or myself would be more than willing to respond. And I do want to note one other thing in terms of the environmental review. So there's been a lot of conjecture and information indicated by the petitioners expressing concerns about environmental impacts. But I want to note all the evidence that we've prepared and submitted that's been reviewed by you as the Zoning Board of Appeals, as well as the Planning Department, is expert-based opinion, meaning analysis by a traffic engineering firm, analysis by a licensed engineering firm. On the other hand, and there could be some new information tonight, there has been no expert information submitted on behalf of the petitioners. The case law is quite clear when you have two differing opinions, one prepared by an expert opinion or supported by an expert opinion, and one that's not, you completely are entitled to legally defer on the opinions of experts and, of course, input from town departments on this project, namely the Planning Department. With all that being said, again, if there's any additional questions, either myself or Mr. Savarino would welcome the opportunity to address them. Thank you.
Thank you. Does any member of the board have a question?
Why is it that you're not looking for a decision on the most recent one? Would it be considered nullified or moot because of the...
Right, so here's the reason, and of course, Mr. Ulatowski confirmed this. Because it's a requirement under that local law adopted by the town board in 1982, that automatically triggered the need to treat this as a type 1 action, which again, requires there to be a coordinated environmental review. The Planning Department did issue a lead agency determination letter on your behalf. Unfortunately for us, the expiration date of that comment period is 2 days from now, January 16th.
We're required to wait that entire...
We're tired to require, yes. Otherwise, it could be challenged as arbitrary and capricious based on failure to comply with procedure. We would automatically lose, in my opinion. And second of all, because there might be additional information provided by those involved agencies, I think the appropriate course of action, your town attorney's here, is to leave the hearing open.
Any other questions? All right, anyone here to speak on this item?
Good evening again, everyone. Colin Knorr, I represent Mark DeJory, who lives next to this property. I appreciate the applicant acknowledging the requirement that this be treated as a type 1. I'd like to take the opportunity to again ask the board that it rescind its prior variances and treat them as a type 1 now that this project has moved and triggered that requirement. I also want to point out in the slides that Mr. Hopkins shared related to the waterfront consistency plan, they make reference to the geological report that was prepared in 2016 that was prepared for the prior project that was proposed by a different applicant. We pointed out previously that that document very clearly calls out that it cannot be used for a different project such as this without additional engineering review. So we would urge the board not to vote on the waterfront consistency, approve the waterfront consistency finding without that document having been updated properly. If the board has any questions, I'm happy to answer them. Otherwise, I believe that's all we wanted to raise tonight.
Any questions? Go right ahead.
It's important to note, and it was included in the PowerPoint presentation, we have submitted an amended waterfront consistency form, which is required. That didn't apply in 2016. And then in terms of the request made by Colin Orr, that you go back and rescind the negative declaration that you issued last fall. I would note within their pending Article 78 proceeding, they did not claim that this was a type 1 action. They did not reference the law adopted by the town board in 1982. And as such, they've waived that. They can't go back and challenge that. They filed their verified petition. So that would be inappropriate, in my position, illegal. The action that's in front of you this evening does require that coordinated environmental review. You're doing that, but it certainly would be inappropriate. And again, in my position, illegal, go back and rescind that negative declaration that was issued after months and months of environmental review. Thank you.
Thank you. I'm happy not to, to adjourn it for tonight.
Move to adjourn.
Do a motion to adjourn. Do I hear a second? Second. A second. All in favor for adjourning the item, say aye.
Aye.
Any opposed? Thank you. That passes 5-0. We have the deputy clerk handed out a calendar for the upcoming year. It was amended from the previous calendar that we received. Do we have any issue with approving that calendar?
Yeah, we don't approve it. But just for the town board's future reference, take it for what it's worth, but 2 of these meetings are during the school breaks for the local school districts, so you're going to be missing people from this board at hearings in February and April. So just for future reference, might want to be, the planning board should be cognizant of that. I'll forgive you.
All right, thank you. Can we get a motion to adjourn tonight's meeting? Either way, adjourn the one item. Okay.
Motion to adjourn. Second.
Motion by Gergen, second by Schubert. All in favor, say aye.
Aye.
Aye. 5-0. Thank you.